doing activities of our business that are a kind that we don't keep records of. So we really can't have a view until we know what the detail of the scheme and arrangement is. But we thought it might be helpful for the community just to hear from an operator about how it does retain certain information and how it keeps that very secure. And that, in fact, the scale of a business like ours and the focus of our customer market is such that, you know, we place a very high premium on our ability to deliver secure services to a range of customers that really want that and protect that information. That might be contrasted with other operators in the sector that don't have those business concerns. Put it that way, they might be focusing on another section of the market, the cheaper residential end of the market. And if those operators were required to maintain certain records, there would be a concern, I think, that they may not be able to do that in a manner that's going to actually secure that information without huge costs and exits from markets and lack of, you know, we would have potential competition issues that might flow from that. So, you know, we're talking about our approach to security issues, both network issues as well as retention issues, but we think that probably needs to be contrasted with many other parts of the market where maybe those concerns aren't as strong. And so in looking at what the regulatory arrangement should be, it wouldn't be appropriate just to think that everyone can turn on their services and have them as secure as a Macquarie Telecom.
Yeah. So would it be fair to say that as far as that issue, which is, I suppose, I think at the moment, end up this way, but at the moment I think it's the most contentious proposal that this committee is examining. I think I don't think committee members would argue with that at this point. But your approach on that issue, or the perspective you're coming to on that, is largely one for the of business and technical concerns that proposal raises. That's my interpretation of what you're saying to us. Whereas the Privacy Commissioner, for example, had a whole range of other concerns. Would that be fair?
That's correct. I mean, there are obviously public policy issues here that are really matter for policymakers and not for, we don't think, individual corporations like Macquarie Telecom. But we can assist you in trying to give you an understanding of the different level of sophistication within the markets, the levels of investment, the implications of a public policy consideration of privacy and how that might play out in as it were, the commercial real world, where we're here to help be that filter. And that's why I note that there would be some operators that would find it very difficult to have document retention, secure arrangements of a kind that say, Macquarie Telecom can do. And so when looking at the response that the market might have to any measures, just ask that the committee take that into account. And in fact, it might be an unintended consequence that there would be less secure information and a greater ability for those with nefarious purposes to access information under a potential new arrangement.
Thank you.
On page 3 of your submission, you say that the reforms, and you don't identify which ones, leave a significant part of Australia's communications infrastructure potentially exposed to higher security risk. Isn't it possible that the data breach legislation, if they brought that forward, would be, and if it was legislated, that it would be an expensive proposition as far as your company is concerned too, and other players in the telecoms area?
I think on this matter, just like to make it clear, I'm speaking on behalf of our company and not a broader position, because I don't have that. And we're actually, we favour the use of breach notification, which is and in fact we would undertake to do that voluntarily as a company to our customers. So if we become aware of a breach of information by one of our customers, we undertake to provide details of that breach to our customer. Now, that hasn't happened.
over the last year. Legislation is passed.
Yeah, so we don't necessarily think legislation needs to be in place. It can be voluntary codes where operators undertake to provide a breach notification to a customer on the occurrence of a hack or a breach of the data. We think that actually would go a long way to give greater confidence with consumers about using online services, because if I think there is a better informed market, and a market's going to operate more securely in a more sophisticated manner if people are aware that if something goes wrong, they're going to hear about it from their provider, rather than just wait until one day they look at their credit card records and find that they bought something that they know they didn't. Those examples that we used previously about Sony PlayStation's customer information being hacked and made available on the internet, that included credit card information, I understand. So in those sort of circumstances, we think the operators really do a disservice if they don't tell the customer first that something might have happened, and then work with the customer to be able to do whatever measures that are needed to be done to protect information or protect financial records or what have you. So I think breach notifications are a good
business practice and proactive.
Yeah, and again, that sort of demonstrates that there are aspects that the market is responding to the concerns that the community has around the risks associated with the digital economy. The other way that we're trying to also educate is to ensure that, and we think that there's a role for government here, that information should be onshored wherever possible. Data about Australian citizens, private information about Australian citizens ought to really be retained by businesses and government onshore as a default position, so that if there is issues around breach or concerns around privacy, Australian citizens have a right to exercise Australian law, and they can go to a privacy commissioner for redress. They can use the Australian legal system. However, if data is kept offshore, especially of a private or personal nature, or it's around governments taking information offshore, the ability for a citizen to exercise their rights of redress are greatly reduced.
I'm not sure that's canvassed very widely in the Attorney General's paper, but it actually sounds like a very important and good idea, and perhaps ought to be part of the Attorney General's consideration for legislation.
And just to sort of use my chair's privilege here, so what would your position be on offshore cloud computing?
We think that perhaps if I just take a step back, and I think it touched upon what I was just trying to elucidate, is the use of cloud computing. We see, we sell cloud computing services, Macquarie Telecom, and we see them as a fantastic opportunity for Australia in a couple of respects. One is it's lower cost of doing business, and all sorts of benefits around lowering power costs and faster compute times. It works with the National Broadband Network. So it's a real centrepiece of a digital economy here for Australia, cloud computing. There are issues, though, around customers putting their private information in the cloud and finding that it is then going offshore. And again, in those circumstances, like I mentioned before, where you have a breach, and let's take a credit card details. So you use your credit card to buy a service via a cloud computing service. Maybe it's you buying music, maybe you provide that information. It may be being retained in a foreign jurisdiction.